welcome to At the Bar, a spirited conversation about issues at the intersection of law, politics, and culture. I'm Inez Stepman from Independent Women's Forum, and I'm here with my colleague, Jennifer Braceras from Independent Women's Law Center.
Hey, Inez, how are you?
I'm good. Jennifer, how are you?
Good. I'm excited to talk about this topic today. We're going to be just sort of going over the standoff between Texas authorities and federal authorities at the border. It's been in the news a lot lately. And we're going to talk about the political aspects, the sort of media aspects, the substance of the debate, and also we will consider whether states have a legal and constitutional right to take action to stop illegal immigration when the feds have failed to act. The issue came to a head last month when the United States Supreme Court vacated a lower court's temporary injunction barring Border Patrol agents from cutting barbed wire installed by Texas along the Texas-Mexico border.
So this case is super interesting because, and the sort of litigation that will spring from this whole situation is really interesting because, as most people know, this is a situation in which the federal government is declining to enforce the law that is actually technically on the books written by Congress along our southern border and has declined to do so for a long time. And so in 2021, the Texas governor, Greg Abbott, launched what he called Operation Lone Star, very Texas name, but it's a state initiative to actually deploy the Texas National Guard to put a bunch of razor wire, this will become important, along the border, critically not on the border, a little bit back from the border, and largely on private property, which is an interesting wrinkle in all of this. So sometimes that wire needs to be cut either by Texas or by the Border Patrol for various reasons, including the thing that's going around on the leftist sort of media meme about this case, which is including to rescue people drowning in the Rio Grande in the attempt to cross illegally. But sometimes the Border Patrol and Texas, they disagree about when and where to cut it. And so the Border Patrol overrides Texas sometimes and cuts it where they want to cut it. And of course, this is like this very iconic image of the, in some ways, of the federal government going to the extent of actually cutting barriers and clearing barriers for illegal immigration into the state of Texas against the will of the state of Texas. So in October, Texas sues in federal court to try to stop the Border Patrol from taking down the wire that they have put up and arguing that the Border Patrol, the Biden administration, is trespassing on private property, destroying Texas's state property because the wire is the state property that's placed on private property. And anyway, there's just like a whole tangle that came out from that. There's this there's an injunction that goes up to the Supreme Court from the Fifth Circuit that stops the Biden administration from cutting that wire, at least until the merits of who's in charge here get worked out. That injunction is slapped down by the Supreme Court. So now we're going to argue it out first in Texas, and then ultimately probably on the national level in the Supreme Court as to who actually, what powers does the state have to enforce its own border when the federal government is failing or actively trying not to enforce federal immigration law. So all of that is a long story, long way to say. We have some great guests for you today to talk about this issue.
Yeah, we're joined today by Danielle Huntley Webb, who is an immigration lawyer in Massachusetts. And a member of the Federalist Society, also a board member of Mass Fiscal Alliance. And we're also joined by one of our IW legal fellows, Jill Jacobson. So thanks for joining us, ladies.
Happy to be here.
Super happy to be here.
Awesome. So, okay, as usual, the media seems completely flummoxed over what actually happened here at the court. Jill, I know you've written a short blog piece dispelling some of the myths about that. Can you just bring us up to speed on what the media is saying the court did and what the court actually did and how the case is making its way through the courts now?
Yeah, definitely. So there are two big myths that are going around in the media. The first is that Texas defied the Supreme Court or disregarded what they said. And the second is that there's an invasion that warrants Texas use of federal war powers to defend. So I'm assuming we'll talk about both of those throughout the course of the show. But the first one, that Texas somehow defied the Supreme Court's ruling, is certainly untrue. So as Inez briefly said, back in October, Texas sued the federal government for destruction of property after federal Border Patrol agents destroyed that concertina wire that we just spoke about. And then later in December, the Fifth Circuit Court of Appeals, so the appellate level court in that jurisdiction sided with Texas, and they enjoined the federal government from taking down the wire. But it's important to note that an injunction is a temporary pause pending the final merits of a case. So it's putting a pause on the behavior until it can be fully litigated. It isn't a final outcome in a legal sense, which is really crucial to the disposition here. So then the federal government appealed that to the Supreme Court. And the Supreme Court lifted the pause and they said, okay, while we wait for a final merits decision, while we wait to really hash this out in courts, yes, the federal courts, the federal Border Patrol agents, you are allowed to take down the wire if someone's health and safety is at risk. But they didn't give a reason why they didn't opine on the merits. They didn't say if Texas is allowed to do this or isn't allowed to do this. All they said is, in the meantime, you may take down the wire. And then the media storm took that and ran with it in a way that really isn't accurate.
One of the interesting things I think about the way the media has described this is, and also a lot of politicians, Democratic politicians, have said things like, Texas is in violation of a Supreme Court order, or Texas is behaving in an unconstitutional manner after the Supreme Court said that the Biden administration could continue to do what it's doing. But of course, the Supreme Court never told Texas it couldn't do anything. It basically said, you guys do you, right? Texas, you want to put it up? Go for it. Feds, you want to take it down? Go for it. We're not getting involved. These issues need to be briefed and litigated. And when it comes up to us on the merits, then we'll take a look at it, right? But in the meantime, hash it out yourselves.
Exactly.
Yeah, this really kind of reminds me that the sort of misinformation around this or the sensationalizing of this case really reminds me of the apocryphal quote about Andrew Jackson allegedly defying John Marshall in Worcester against Georgia all those years ago, where that he never said that. He never said the famous quote that a lot of people probably know, John Marshall has made his decision, now let him enforce it. That was from an opponent's newspaper, a description of what Jackson actually said, which was, there's nothing to, I mean, he said it in a different way, but there's nothing to enforce here because there was no actual action for Georgia anyway. But it really reminds me of that debate and how that quote became emblematic of the executive branch defying the Supreme Court when in fact it wasn't. And what we remember is the sensationalist headline from an opponent's newspaper. So I feel like that's very much
and like that. Nobody's defying the Supreme Court here, right? Everybody's just going about their business.
Yeah, so there's nothing, just to be clear, like Danielle, is there anything in the Supreme Court's rejection of this pause, as you say, that one, indicates how they'll rule on the merits necessarily, and two, that Texas can, quote unquote, defy? Texas can just keep putting up the razor wire, right? It's just that Biden is allowed to come down and cut it.
Correct. I mean, that's my read on the situation. It's kind of like almost a status quo. Like, you can put up wire, but they can cut it or take it down. And there's nothing stopping you from continuing to put it up. I mean, I honestly don't know where they will come down on the merits. I think it's a very, it's tricky because you do have a failure of the federal government to enforce immigration laws. But that gets to our structural problem of Congress, do your job. So, if we want to see any type of truly systemic changes to our asylum laws, to our laws about what happens when someone shows up at the border, whether at a port of entry or outside of a port of entry, like that, Congress has to make those changes to even enforce, so one of the things I hear a lot about is, well, it's on the books that these people are required to be detained. And that's true. It is. But the facilities do not exist to contain the amount of people who come to our southern border. And no one seems to be willing or able to figure out how to pay for that, to create that infrastructure. I see this as kind of the like icing on the cake of Congress, do your job. And that this is just emblematic of how broken our system is. I mean, it's pure insanity.
So we'll get into, I think, a lot of those issues about whether the states have the power to supplement and use their own resources in accordance with what are still the rules on the books, right? The laws on the books from Congress, which is a really key part of, I think, this case and the thing that really might potentially, or at least I hope, change about our precedent on this. But as of now, just to dispel the rumors, Texas can continue to put up their razor wire, and I have a short clip showing that they're in fact continuing to do so.
Texas and Governor Greg Abbott are making it no secret they're putting in more razor wire at the southern border just days after the U.S. Supreme Court gave the go-ahead to the federal government to remove the wire. In a lengthy statement, Governor Greg Abbott is reiterating arguments he cited before, asserting that the federal government has fallen short of its constitutional duties to protect the southern border. He's specifically citing U.S. Constitution Article 1, Section 10, Clause 3, which says in part, no state shall, without the consent of Congress, keep troops in time of peace unless actually invaded. Governor Abbott has said the state is being invaded. The question is, would the courts agree?
Yeah, so Jill, that's where I want to bring you back in here, because you were saying before that that's sort of also a misnomer in the press, and perhaps you think Governor Abbott is wrong in his description. Maybe it's a legal tool he's using to be able to accomplish his objective. But my sense is that you don't think that he's actually right. So I don't know. Tell us, do you?
Yeah, I think just to touch on the outcome of the Supreme Court case, there's an avenue because of the posture of this case that the Supreme Court does not opine on immigration at all. Because of the posture of this case, I mean, the federal government is normally immune to tort suits. So they could throw it out on sovereign immunity and not give us any advice about the situation at the southern border at all. Given the current makeup of the court, I don't know if that would happen, but that
so if I'm not mistaken, let me just stop you there, and I confess I didn't read the district court opinion, but I believe from what I read, the media accounts of it, that the district court essentially said just that, right? That they couldn't sue the federal government on this at all.
Yeah, exactly. Generally, the federal government is immune from tort suits, and this is a destruction of property suit. So, the Supreme Court could disregard that and choose to answer some other questions. But I think most people would predict it rules narrowly. At least it should, if possible, and it might just be thrown out on immunity grounds, and we won't have any guidance whatsoever until the next squabble.
So it just to consider the question of whether or not this is an invasion, and whether or not this clause that the governor is invoking is the right clause to invoke. What do you make of that, Danielle, as an immigration attorney?
I mean, I've always understood invasion in the Constitution as something that involves an act of war, an act of a militia, an act of an armed force. I think what we have at the southern border is a humanitarian crisis of cartels trafficking people because we do not have a functioning immigration system. So is it an invasion in that there are a lot of people showing up at the southern border and overwhelming resources, and that bad actors are profiting off of this to the tune of billions of dollars? Yeah, but I don't think that, I think like what Jill said, I don't think that kind of fits into the definition of invasion as it's been historically understood in the Constitution. But that doesn't minimize, in my view, just kind of the absolute horror we're seeing at the southern border. I mean, it's a really, really bad situation.
What about the second argument? Let's move to the second argument that Governor Abbott actually puts forward, right? Because there's the invasion argument, which we've just talked about, and I tend to agree with you that the definition of invasion, the colloquial definition of invasion, this might fall under.
Yeah.
So I don't think it's necessarily. I'm sure a lot of people feel like they're being invaded. I
Yeah.
feel like I'm being invaded because the migrants that are the hundreds of migrants who are hanging out in the park, three blocks away from me. But I tend to agree with you, Jill, and with Jill's blog post and what Danielle just said, that probably this is not an organized and armed invasion in the sense that I think the Constitution imagines it. But Governor Abbott makes a second.
Wait, before you get to the second argument, I would just throw in that some people have made the argument that invasion requires both entry and enmity, right? Like you're not just coming in, you're coming in to do harm to the United States or to people in the United States or to the body politic of the United States. And others have countered, yes, that's true, but it has to be done by a state actor, right? And they have to kind of occupy territory for it to be an invasion. But at the same token, there are references in the Federalist Papers by Madison to pirates and barbarians as invaders, right? Those aren't state actors. They're not taking territory. They are bad actors, as Danielle said, like some of the cartels who, were at the time, coming to the U.S. to do bad things. And if pirates and barbarians are invaders, not every person crossing the border is an invader, but certainly there are invaders that one could argue. I guess this is Abbott's argument.
I definitely think you can make the argument that a certain subset of the people entering the United States illegally at the southern border are bad actors. I mean, I think there was some type of a news report that it was some number, I think it was like 100 people on the terrorist terrorist watch list were then apprehended by Border Patrol at the southern border. So I think, again, the problem is that we don't know who's crossing the border, and that's why it's so bad, is because we have no clue who these people are. I think, I think where I also have trouble with the word invasion is that the way our immigration system works is that we've incentivized people to come with children. And, I think it's hard for me to say that a 3-year-old is an invader.
Yeah, and there's also an element of organization that's missing here, right? So, like, even in the case of pirates, it's an organized effort. And so, like, there seems like there's a lack of organization that perhaps, Danielle, you're right. Like, some subset of people could be characterized as exactly a pirate-like organized effort to, be hostile towards the United States. But like even people who I think could fairly be put in the category of bad actors, and actually I think a lot of we have a smaller problem these days with that was the like last year's or 3 years ago's problem was the families because of our the Flores settlement and everything else. Now, like I can just say firsthand, the migrants getting off the buses in New York, they're primarily young men between the ages of 18 and 25. That's who's coming, and that's people I think point to that and say, well, this does look more like an invasion than, as you say, families with children in tow, right?
Yeah, Inez, I might just underscore that and suggest that an originalist reading might require a jeopardy of sovereignty, right? In a lot of these early texts, including most of the founders underscored that it has to be a threat to the United States' sovereignty. Organized pirates who want to disrupt economics, foreign militaries, those sorts of things, they're attacking the sovereignty of the United States. And while these migrants might be of a certain age, some of them might be bad actors, is there sufficient organization and adversariness to suggest that they're jeopardizing sovereignty? Even organized crime groups who are seeking to traffic drugs into the United States, harm migrants, profit off this situation, all of those things. They might be bad actors, but I don't think they necessarily want to jeopardize the sovereignty of the United States such that they would fall under the invasion clause. We can go back and forth about their motives, but I think that is a crucial part.
I do think politically the use of the word invasion is interesting. And I think it's something that, in a way, benefits both the far left and the right. And that is, when Governor Abbott says it's an invasion, it benefits, I would say, the conservatives, the right, in the sense that he's grasping on to a constitutional hook to justify what they're doing in Texas. And so it maybe bolsters his legal case potentially. But it also creates, an image of these people are invading our country, right? Which is sort of the very far right view of illegal immigration. The left loves that because they love to be able to say these conservatives just hate brown people from Latin America and they regard them as invaders and occupiers and blah, 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 blah. And so in the final analysis, I think it's actually just not really helpful way to look at it. And what I would argue is, why does it even matter if it's an invasion, right? Why does the Compact Clause apply at all? Like, the Compact Clause refers to states committing, going to war. Like, Texas isn't engaging in war. They're putting up some wire. So why do we need to say that this is necessary because it's a war against invaders? Like, they're not even doing that. They're just putting up wire. Like,
I'm laughing because I have I guess I have a opposite. I just agree completely with what you characterize the far right view as a matter of colloquial speech. I think this is an invasion. Leaving aside for the moment, what the original meaning of the word invasion in the Constitution is, and there I think I do agree with Jill, with Danielle about there is some element of organization that's necessary. I like the jeopardy of sovereignty. Like, that rings kind of fundamentally true to me. Right? That there is some essential element of that in technically what I would call an invasion.
But I guess
in terms of a matter of rhetoric, I mean, I think it just underscores the severity of the problem.
I guess, but if it's not legally quite right, which is the point that I think the three of you are making, then why use it at all? Like, it's just political rhetoric that I think then the left is able to kind of use against Texas and other border states, when in fact, what is Texas really doing? Are they repelling an invasion? Are they initiating an act of war? Or are they just securing their borders so that people who aren't actually citizens can't illegally come in? Like, I just think...
I mean, I think that the proof is in the pudding, in the sense that they're not actually repelling an invasion, because that would involve, like, if there was an actual invasion of an organized army, we would expect them to be shooting.
Correct.
So in that pragmatic sense, I think not. But I guess I have the totally opposite instinct politically, because actually I think one of the most successful political gambits in this issue has been sending migrants to cities like mine, to big blue cities. I think people now... I think even people in blue areas now understand why someone would call it an invasion. Anyway, so that's like sort of here nor there. We have differing political sort of utility of the word invasion, but I think we are sort of in legal agreement. No, that this is probably an argument that's unlikely to prevail ultimately.
But I think we're all in policy agreement, right? That the border is not secure. The border needs to be secured. The federal government isn't doing its job, right? We all agree on that. And frankly, I don't know. I think we all agree. I certainly agree that Texas should be able to protect its borders if the federal government isn't going to.
So let's move then. Go ahead.
I'm curious how this strikes you. To me, the word invasion sort of takes the primary actor away from the US government and puts it on a third party. I write in my blog, I say it's not an invasion if the executive has its arms wide open, because migrants suggest that there are two groups working synonymously, right? One is letting them in and the other is entering. But invasion suggests that we are doing all that we can. And despite that, they still have managed to enter the country, when that's not what's really happening at all. It's creating the illusion of governmental action, specifically executive action, when there really isn't any. I don't know how you invade someone who's opening the door for you.
I think that's a good point. So I do want to move, because I think we're running out of time to fully discuss the other issues. I do want to move to the second argument that Greg Abbott makes in this letter, which I think is actually one that has a lot more chance to prevail legally. And that is essentially, he's citing Scalia's dissent in Arizona against the United States in 2012. You have Arizona, if the word SB 1070 means anything to anyone. This was Arizona coming in and saying that their police officers, state officers, were going to start checking immigration status of people they stopped in the course of their work, right? And that they were going to arrest them under state law. So basically, Arizona duplicated the congressional law on the state level. Said we have a separate law. It matches with what the feds say, but we have a separate law. It's a state crime to be in the state of Arizona illegally in this way, and we're going to prosecute it as a state crime. That's my understanding. I'm still trying to remember but so there was, this is the part I do remember, is the legal reasoning, where you have Kagan, who had to recuse herself because she had been involved earlier. And so you have the potential for this 4-4 split on the court, right? Over this issue of whether Arizona is able to essentially duplicate federal law. And John Roberts switches over to make it 5-3. And the reasoning of the majority in that case is that the plenary power of the federal government over immigration it fills all corners of the space, right? That the states cannot legislate at all with regard to immigration. And so even though this is sort of a duplication of what the federal law actually says, that even federal enforcement priorities have to take precedence and boot out essentially any of the state involvement. So then there's these two dissents in this case. I think Alito also had one, but two that I are relevant, I think, for this. One is Thomas saying basically duplication is not, there's no challenge to actual federal law here. There's only a challenge to federal enforcement priorities. And if the state wants to come in and enforce its own law in accordance that it has no contradiction with the federal law, there's no actual conflict here. And then Scalia says, yes, I agree with you on that, Thomas, but also I think the state, and so he advances this theory that Abbott cites in his letter, which is the concurrent state sovereignty theory, that if state sovereignty means anything at all today, then it means the ability, and this is where it folds back into invasion, to repel unwanted people. So like obviously not other Americans from the state, but that to repel unwanted foreigners is such a fundamental aspect of sovereignty that the states actually still retain that element of sovereignty even after the 14th Amendment and the Civil War. So those were that's the background. So now we can.
The federal immigration law wins is basically how I understand the case. Because as a practitioner, I'm in the day-to-day. How does the system actually work? So I think how this situation interacts with that case can be you can look at it with a practical example. So I'm an illegal alien. I come across, I enter into Texas. Have we now, if Texas is able to pass its own immigration enforcement scheme, whatever that may be, does that then prevent ICE from picking me up? Does that mean now I just have a race to get to New York where they don't have their own enforcement scheme? Does that mean that I think that's why the federal supremacy of immigration law is kind of important. because we don't have hard state borders. So, for instance, during the COVID-19 pandemic, I live on the Massachusetts border. I live in New Hampshire. The rules in Massachusetts were very intense. And so at the beginning of the pandemic, I technically was violating the law by going to the grocery store, where the grocery store is in New Hampshire, but the parking lot is in Massachusetts. And so I think that's where this tension kind of comes into place, where from a practical standpoint, if you have 50 different immigration enforcement mechanisms, it's going to be absolute chaos. What needs to happen is for Congress to do its job and to reform our asylum system, to reform how do we process people at the border, and to give the funding so that people aren't released into the United States. So to get rid of the Flores Declaration, to have the facilities to detain people so that their claims can be processed. And if they don't qualify, they can be removed. Because right now, the incentives are, if you can get here and you can get in, that's the hard part. And if you maybe show up to court, maybe you do have a legitimate asylum claim. You probably don't. Most of these folks don't. They're just fleeing economic poverty and general unrest, which does not qualify for asylum. I get the impulse. I get Texas's impulse, but I don't see how it works from a practical perspective. I think it would create chaos.
I mean, I certainly agree with these. Sorry, go ahead, Inez.
I think the thing that Scalia was pointing to, and Thomas did it as well, and Jill very kindly dropped it in the chat for us, right? So, and I'm going to read a bit of Scalia's dissent in Arizona, which is: the majority's decision deprives Arizona and any other state from furthering its sovereign right and power to exclude people who have no right to be in the state. Moreover, the mere existence of federal action in the immigration field does not mean that a state is powerless to also act in that field. The Arizona laws being challenged do not extend, alter, or revise federal immigration restrictions, but merely enforce current federal restrictions more effectively. So I want to bring an additional element into this discussion, which is we have a court now that looks, let's say, with more skepticism towards sorry, it's a summary, not actual part. Okay, sorry, Jill. I don't want to. I just want to.
But it's so well written. It sounds like Scalia.
Yeah, exactly.
There you go. Kudos to you, Jill.
So I want to bring in this additional element. We have a court that now looks skeptically, let's say, or with more skepticism than courts in the past have looked at, to essentially administrative action that bridges into the legislative function, right? We have this administrative state, we have this executive branch that is operating in many ways as a sort of illegitimate legislature. And this court, as we saw in cases like in the West Virginia case, the EPA, we've seen this court chip away at Chevron deference. We've seen this generally skeptical posture towards what are essentially extra legal actions by executive agencies. Here, I think, just like in the Arizona case, we have no actual conflict, right? Because I think, Danielle, you're speaking to, okay, well, it would be totally crazy if we had 50 different enforcements of immigration law, right? But here...
Do you think New York has a problem now? I mean, blue America will be invaded if you have, which actually might be a good thing because it would provide the incentives.
I don't think that's true, at least under the understanding here, right? So, because somebody asked me this when I was chatting, I did this space on Twitter, and a bunch of lawyers and people talking about this, and somebody asked the question I think you're exactly pointing to, which is, can then under this kind of structure, if we overturn Arizona, can a blue state knock down the wall? Let's say that the Trump administration part 2 builds a wall, and Arizona, or let's say California goes in and knocks down the wall that the feds have built. I would say that that's actually a totally different case, and that would be a direct contradiction to federal law, assuming that Trump actually got the funding in Congress for the wall, right?
So here, right
Here
here,
it's
the state is
executive
just
priorities
enforcing.
versus state law.
Yeah, I mean, here the state is enforcing, like you said, the laws that are already on the books. It's not a situation where, for example, Massachusetts is saying we're going to let in all people from country X, and irrespective of what the federal government says. And Texas is saying, yeah, no, we're going to let in all people from country Y, but not country X, and they're right, and they all have these completely different policies. No, the policy of who can come in and how they can come in is set by the federal government. Nobody disagrees that the federal government has the supremacy to do that. I think the question is, and what Scalia raised in his dissent / concurrence in Arizona was absolutely why can't the states take action to enforce federal policy? You kind of have that situation right now in a completely different context, in the Title IX context, because you have Title IX, which is a federal law that prohibits discrimination in education, including sports. And the federal government is essentially, allowing biological males to compete on women's sports teams because of the way they misinterpret Title IX. You have all these states passing laws that say, women's sports are for women. And then the ACLU goes and challenges them in court. And, in a recent federal district court opinion in West Virginia, the judge, a Clinton appointee, I believe, said the state absolutely has a right to do this because the state is just enforcing Title IX. When a state says women's sports are for women, we don't want women to lose opportunities / be discriminated against in sport, that is just enforcing the Title IX's mandate. And I see what Texas is doing here as exactly the same.
Yeah,
Not exactly, but
I'd agree with Jennifer. I feel like it's important to underscore that this isn't happening because there are no laws on the books, right? It's not as though Joe Biden or the Biden administration has nothing to enforce. There are laws there, and he took an oath to faithfully execute them, but they're not being executed. There's no enforcement. So there's no need to create something else out of whole cloth if they were being enforced, which they're not, which resorts then to Texas essentially doing what is already codified at a federal level, just not being enforced.
Yeah, but so then a practical extension of that is, so does Texas then indefinitely detain these people?
I think so. Then Texas passes a concurrent law, so it would be they can send them to jail under a state law that does not. So just like if you're, and maybe I'm getting beyond my depth here, but if you're let's say you're selling pot in a state where it's still illegal, right? There's a federal charge that goes along, and now we can discuss whether the federal government should be involved at all in drug law, right, or whether that's purely a police power matter. I tend to think it's a state. But for the purposes of argument, we currently have a regime where marijuana is an illegal substance according to federal law. Let's say the state also has a law on the books, as until recently almost all of them did, saying, selling pot is a state crime. My understanding is and is that they have created a state crime for which they allow the judge basically an out instead of because they probably don't want to incarcerate all these people. That's really expensive. They allow the judge essentially as a mitigation to say, well, if you leave the country, we won't put you in jail. So they are trying to create these concurrent laws.
So how does that work with someone with a pending asylum claim? Is that Texas judge now denying them due process?
That's a really good question.
Yeah, Danielle, I was going to ask you because to my knowledge, this is circumvented and almost rendered obsolete by the fact that the overwhelming majority, the second that they step foot in the United States, say, I have a credible fear of returning to my home country. But once you're in the asylum bucket, you're no longer illegal. There is no crime because you're waiting to seek asylum. Right. So you're sort of taken out of the criminal arena and put into this entirely new bucket little do we realize it's made up of practically everyone now, because they're told to claim asylum the second they get here. So those laws wouldn't even address the core problem, because they're all sort of waiting in purgatory in the asylum system. Is that right, Danielle? Or
yes. So that's, I mean, because under the law, once you are able to convince a Border Patrol officer that you have a credible fear, you are in the asylum system. Under the law, you are entitled to a hearing before an immigration judge.
And you're no longer illegally. You're no longer an illegal entrant, right?
So what your status is in the United States, that's a very technical, like what your actual status is in the United States is kind of a very, you're kind of in a quasi status because you're technically not in status. And the reason why I say that is because if you were in status, you could be entitled to other immigration relief. So like a work visa or some other thing. But so they're kind of in this like quasi holding status of having a pending asylum case. And that's again a totally federal process. There is no way for the state to enforce that. There is no way for the state to be involved in that. I think that's why these attempts at the states to detain people like really backfires. I mean, are we going to have the state of Texas detain people while it takes 7 years for someone's asylum claim to make it through the asylum system? I mean, that's cuckoo. Or, I mean, frankly, what I think needs to happen is that Congress, again, needs to do its job and reform our asylum system. And also make it possible so that there isn't this massive catch and release. So that, I mean, you hear the joke about Harvard, right? The hardest part about Harvard is getting in. The hardest part about the United States for low skill, kind of these economic migrants is getting into the United States. Because once you get into the United States, unless you get arrested or whatever, you can basically lay low, disappear. And even though you are in the very bottom and dregs of our society in terms of the lowest kind of income potential, you're still earning orders of magnitude more than what you would earn in your home country.
Can I ask you a question, Danielle? What happens if somebody, so in that limbo status, they've claimed asylum, they have a court date 5 years from now, and they're released into the country. Obviously, it doesn't prevent them from committing other crimes, right? If they commit another crime, a state crime, say like the 5 guys who beat up the cop in New York, then they're tried under the state law,
correct,
and either deported or I guess that would be a federal action, or they're put into state prison, right? If they're like, why can't the state then say there is a state, like being in the state of Texas illegally without a right to be here is like a state crime in the order of, running someone over with your car. But I think you're right. Then there really is a conflict with like the asylum law, the federal one.
Yeah, no, I mean, it conflicts with the international treaties that kind of serve as some of the basis of our asylum law. I mean, that's the problem, is that once you get here, you can disappear basically. Now, what will happen typically when someone is arrested for a violent felony or something like that, they're arrested, they go through the court process, and then what happens, and then they're sentenced, they serve their sentence, and then what happens at the end is that ICE is notified and ICE will come get them. Because the idea is not that like let's say you're some high up member of a Mexican drug cartel, you murder someone, and then you say, hey, just send me back to Mexico. That doesn't happen. Then the person serves their life sentence. They may never go back to Mexico, but because so many criminals would choose over jail, just, all right, I'll just leave. Bye. And go live in my country where I won't be incarcerated. So I think that's the real tension here. And it's emblematic of immigration is really, really complicated. Really, really complicated.
So let me ask this then. Let's return to the question of the razor wire, because I think I'm going to have to think through it myself. I think, you're right. You've brought up a real conflict if somebody says they have, or if somebody is granted asylum, whatever, pre-status, pending their court date by the federal government, then you really do kind of have a conflict between the state. If the state wants to make it a state crime to be
Well, and
illegally
also
in that state, I guess you can leave the state.
Can I give you just
You're allowed
one
to be
other
in the-
example? Can I just give you one other example? So there's something called temporary protected status, TPS, which is determined by the federal government, and it's for things where there's like a humanitarian disaster. So for instance, Haitians after the 2010 earthquake, if you were here in the United States, even if you were here illegally, you could get something called TPS, which gives you temporary protected status. It gets you a work permit. They're not in status, but they have a status. So could Texas detain those people then too? Even though the federal government is saying, no, we're giving you temporary protected status and you're here, but you're still technically illegal. Like if you murder someone, they're going to deport you.
So then the question is, you really do rely on whether, I guess then the real legal question here has to be not just the half that both Thomas and Scalia agreed on, that if you duplicate federal law, that the state has some power to enforce it, to go against essentially the enforcement priorities of the federal government, as long as they're not contravening the law. Then you have this second, the necessity of I guess the second piece of the Scalia dissent, which is this concurrent sovereignty and the right to exclude. And I wonder if one of the solutions that we might see happen is essentially they can't take them out of the asylum status or pre-status that you're talking about, but they can say leave the state. And it just ends up directing, like all the red states pass these kinds of laws and all the blue states don't. And so it just ends up directing all of the asylum cases to blue states. I mean, that'll be that'd be really interesting politically.
Yeah.
And I'd be curious to know what percentage of all immigration claims are asylum, because there are millions. I mean, I think, Danielle, correct me if I'm wrong, the wait list is like 8 or 10 years or something unbelievable. I mean, you will never have a hearing at this rate. So I'm curious, what percentage of all claims is this asylum bucket with this strange nebulous status?
So the immigration courts currently have a backlog of 3.3 million cases. And that's just immigration court. So those are people who are in removal proceedings. You can also apply for asylum affirmatively. So you can enter the United States via a visa. And so you've come on a tourist visa or a student visa. I just did a consultation for some Chinese Catholics yesterday on applying for asylum in the United States because they will be disappeared if they return. And that's an affirmative case, and that you file with USCIS directly. I believe the last time I checked, the wait for an interview for USCIS is about 7 to 10 years, and they're doing right now last in, first out. So like I have a pro bono case I filed on behalf of a woman feeling a terrible story, fleeing political sexual violence in Haiti. And we filed 7 years ago. I have no idea when her interview will be.
So that does really highlight the brokenness of the asylum system. But I guess I'm with Jill. What percentage of people at this point on the border are claiming asylum? Probably pretty high. I know people.
They all are.
And anyway, so like that yeah, I think that I'm learning something here. I really think that there probably is a conflict to some degree then between the actual asylum laws and the potential state crime but perhaps not if the crime is not being in the country illegally, but being in the state of Texas illegally. Potentially there isn't then a conflict between federal and state law. Anyway, this is very interesting. I know I've learned a lot. I hope from this discussion. One final question to sort of wrap it up and where you see this going. So we now have the posture of this case. The injunction is dissolved, right? So that the feds can cut the razor wire, Texas can keep putting it up. So where do you see this going? This is now going to be, we're going to argue out all the things that we've been talking about, right? In the Fifth Circuit, is that right? The next step here. And then what do you expect from those arguments in the Fifth Circuit, and then potentially, so we have a whole bucket of them, right? We have the invasion clause of in the Constitution, right? We have the concurrent state sovereignty idea of Scalia. We have with the right to exclude. We have the potential sort of non-conflict between state and federal law, which may or may not be complicated by asylum law. And then on top of that, we have the fact that this is on private property as well. So we have like this additional wrinkle that these are property owners who permitted the state of Texas to put up the wire, but do not want the federal government to cut it, right? So I tend to think that's probably going to be pushed aside. But Jill, you pointed out, that this provides a narrow ground for an immunities ground for this whole case to basically be dismissed. So what I know predictions are just opportunities to make fools of yourselves in these things. But if you were to permit us to make fools of you, where do you see some of these issues going in the Fifth Circuit and then in the Supreme Court?
Yeah, I mean, I have a rather anticlimactic prediction, I think, which is that, I don't think the invasion question, I don't think we'll get an answer. A lot of courts have heard that and they've deemed it what's called a non-justiciable political question, which basically says, this is not our job as the courts. We're going to let the political branches handle this. At least that's how it's been handled in the past. Who knows? Maybe with this court, we'll see something different and they'll answer it. But up till now, that they haven't agreed to. So I don't see why they would at this point. So that's my prediction for the invasion question. And then as far as the private property one, I would not be surprised if they held that it was blocked by governmental immunity and they kicked it as well. Who knows, based on the litigiousness of Governor Abbott's administration and our current Solicitor General, who knows, maybe there will be another sort of iteration of this to come up at the court before this is over. But
because it's right. This case, one thing to keep in mind is that the case was brought by Texas. The case was brought, Texas is suing the federal government to get them to stop doing something. But it very well could take a different iteration where the federal government is going to court to try to stop Texas from acting. So in that case, the legal issues would be slightly different, right? And it may be that the courts say Texas doesn't have the right to block the feds from, like, we're not going to deal with this, but if it came at it from a different posture, they may decide something different.
I think federal courts hate dealing with immigration. They hate it. So I think they're going to try to bounce this on as limited a kind of posture as possible. So I think they're going to, I think they'll bounce it on sovereign immunity. I think they'll say, sorry, Texas, sovereign immunity. This is, that's what I think is going to happen. I do think the case of the federal government suing Texas for this behavior, I think, is more interesting because I think it then gets into like more private property rights of the private landowners. But then also there's this special magical 100-mile from the border zone. And then the government has, I believe, can enter any property, any land that's within 25 miles of the border, even if it's private land, they can just enter it. They can't go into dwellings. So, how do they deal with the argument that the razor wire or other barriers are impeding that 25 miles of access? So, I mean, I think the Supreme Court is just not going to want to, because this is ultimately going to get to the Supreme Court. Right. I think they are going to not want to deal with it and send it out on sovereign immunity issues. That's my guess. And I'm probably wrong.
Well, we'll have both of you back if and when any of these things actually come to a decision on the merits, and we'll either congratulate you or mock you for your.
No, we'll never mock.
I'm just kidding. Jill Jacobson, Danielle Webb, thank you so much for joining us today at the bar to discuss everything from invasion to asylum here.
Thanks, guys. This was fun.
Thanks so much for having me. I had a great time.
So at the bar, which one of us is going to close it out, Jennifer?
You close it, Inez.
At the Bar is a production of Independent Women's Forum. It's available for viewing on Facebook, YouTube, and IWF.org. And you can also listen to this if you are doing so now as a podcast on iTunes, Spotify, iHeartRadio, or wherever else you get those podcasts.
We hope you'll join us next time for another spirited conversation about issues at the intersection of law, politics, and culture. Until then, cheers.